Hello everyone. I am Ahana Bhaduri, Assistant Professor, Department of Biotechnology, Haldia Institute of Technology. Today I am going to talk about the fundamentals of intellectual property rights. Before going into the basics of the intellectual property right, we will deal with the very basic term, that is property. Now, what is a property? It is real or intellectual goods that are commonly recognized as being the rightful possession of a person or a group. Now, when we talk about property, basically three things comes to my mind. That what is a property? Property is somewhat obviously that we all know comes with ownership. Okay, now when it is coming with ownership, obviously property deals with possession. And when it is ownership and possession, the third thing and one of the most important thing about property as well as intellectual property, that it has got exclusive rights. So exclusive right allows the owner to exclude others from using his property and also has all the rights to sell, license and use his belonging. So if we look into the examples of a property, so we all know that a house, a piece of land, apartment, gold, car, any legal belonging of yours is a property which actually you have a ownership on, you have possession and also you have the exclusive right. You are the only one who will decide that what to do with that property of yours. You can sell it, you can give it on rent, or you can use it by yourself. You are the only owner of your property. So now coming into the types of property, there are two types of property, tangible and intangible. Tangible properties are those properties which have certain defined physical form and can be perceived by a sense. For instance, those which can be touched. Okay, now we can take some example like money, like car, like gold. These are all actually examples of tangible property which you can actually feel, touch. Okay, now on the other hand, intangible properties are those which lack physical existence and cannot be perceived by senses. Now, what are the example for this? A person who is capable of writing a book or a person who is capable of composing music. So, these kind of composition or composing book, music is actually, these are all intangible property and you cannot touch it or you cannot feel it. Now, since we have a basic knowledge about what is a property and type, so it will be a bit easy to understand what is an intellectual property. So intellectual property, now we understand that it is intangible property. It is a creation of mind. So intellectual properties are the creation of mind, such as invention, literary and artistic work, symbol, names, images and design used in commerce. For example, a movie, making film, writing a script, writing a book, okay, or any kind of new invention in scientific world, all will be protected under intellectual property rights, and these are all intellectual property. These are not only property. Intellectual property rights are the rights gained over creation of intellect and the rights over property which is result of the intellectual effort. Now, since intellectual property is something that you have created out of your own intellect or out of your own imagination, this is at most necessary that you should protect the invention or the creation you have made. As property gives you ownership, possession and exclusive right, if you actually protect your intellectual property, it will similarly gives you your exclusive right, your ownership and the possession. And here it is very important that you get all this right, because if you don't protect your invention, somebody will come and claim it. Okay, suppose I have composed a music. If I don't go under this intellectual property rights, if I don't register myself under this right, somebody else will easily take away, because I have no proof that that is my creation. Only proof that I can give to the world by coming under the protection of IPR. Once I have protected my creation, that is legally I can say it is all legal. Then legally I can claim that no, Mr. X is not the creator of this content. This is me who have created the or composed the music, because I have this legal document to fight on. So it is an utmost important step that you should protect your invention, because this IPR gives you all the facility that ordinary property has, that is the ownership, that is the possession, and the exclusive right. Now coming to the types of intellectual property. So here I have shown in a flow chart that what are the different types of intellectual property. Actually you can choose a particular domain and you can go and protect your invention under this domain. Okay, so let's see that what are the types of intellectual property we have. We have industrial property, we have copyrights and related rights, we have protection of plant varieties, traditional knowledge. Now you can see that under industrial property there are again several subdivisions. So let us look into the subdivision. They are trademark, industrial design, geographical indication also known as GI, and trade secret. Now these four actually comes under industrial property. So you have to choose that what you want to protect, your design or your geographical indication. We will come into the details that what are these. Now here we can see another domain, that is a patent. Patent actually is holds true for scientific invention. It is not discovery, but it is an invention. Okay, so any kind of invention or modification, the modification must also be an inventive step. It is not a minor modification or a common modification a layman does, but it should be a new invention. Okay, so that kind of scientific invention actually gets protected under patent. And as you can see that we have three types of not three types of patent, it is what you can actually protect under patent. You can actually protect process by which the invention is made, the product out of means after the inventive step, what is the new product that you are actually patenting which is very new, and the utility. Okay, so what is the utility of the invention? So these are the three categories where you can actually protect your invention under patent. So let's see in detail about what are the types of intellectual property rights. First one is the copyright. So copyright is any kind of right that the creators have over their literary and the artistic work. So for example, copyright ranges from books, music, painting, sculpture, films to computer program, database, advertisement, etc. So if you compose a music, if you paint, your painting is novel or it is your own creation, if you write a book, you write a novel, you will claim your protection of the invention under copyright. Okay, so you cannot go for patent. Any kind of literary work you cannot patent it. So or you cannot go under trade secret or geographical indication, because they are the different types. So any kind of, we must remember that any kind of artistic work, literary work you are writing, you are composing, you are making a film, so every protection will be covered under copyright. Okay, now the next intellectual property right is trademark. So I think we are all very used to with this trademark. This is something kid to old, everybody knows. Okay, and I have put some logo. Even if I don't write the name of the company, everybody will understand that okay, the first one is a Mercedes. Even if I don't write that this is a Mercedes Benz logo. Okay, and if, and this is a McDonald's logo or a Starbucks logo. So trademark is nothing but a mark that we put on the product. Every company, their own, the product that they make, they will actually give a logo to the product, so that it is very easily you can say that okay, this is CCT or this is Nike or this is a Mercedes. Okay, so trademark is nothing but a sign that is capable of distinguishing the goods from one another. Okay, a bit detail I would like to mention that this is not only the logo we are protecting under trademark, but if you look into the color, okay, so this McDonald's have a red color. Okay, Now we all know that Coca-Cola has also a red color. Air India, the logo, we have a red color. So the color is also protected under the trademark. Okay, it is not only the M that is actually getting, the color is also getting protected, the font size is also getting protected. So including the logo, many other things are actually getting protected under trademark. So what does that mean? That means Air India is not entitled to use the McD red color, or McDonald's red color cannot be used by Coca-Cola. So if any new company for their product they choose this shade of red, they can be in a legal trouble. Okay, so anything they have already, this entire logo has been protected under trademark, and if any company, any small enterprise try to take the color from them or try to mimic their logo, they will be in big trouble. Okay, they cannot, because it has been legally protected under trademark. Okay, now coming to the third, that is the patent. So what is a patent? A patent is an exclusive right granted for an invention. A patent provides the patent owner with the right to decide how or whether the invention can be used by others. In exchange for this right, the patent owner makes technical information about the invention publicly available in the published patent document. Okay, so patent, as I have already told you, it is related to scientific invention. Okay, one thing you must remember, that no discovery can be protected under IPR. Discovery is different, invention is different. What can be protected under intellectual property right? Only inventions can be, or creations can be, or creation inventions can be protected under intellectual property rights. No discoveries is actually registered under patent or intellectual property right. The next type of intellectual property right is industrial design. And industrial design constitutes the ornamental or the aesthetic aspect of an article. A design may consist of 3D features such as shape or surface of an article, or a 2D features such as pattern, line, color. Okay, let's make it a bit easy. Now, what is industrial design? What protection will you get under this industrial design? For example, I have written Benz, Dove shampoo. So what are these? If you notice that every car has its unique design, no car looks same. Okay, so obviously WagonR, a Alto, a Baleno, so every car has their own specific design, and that specific design should be protected under this industrial design. So I am talking about car. If you come down to some minimum objective, and if you see a Coca-Cola bottle and a Pepsi bottle or a Mirinda bottle, all the three PET bottles are very different in shape. Okay, so if you see here that a design may consist of 3D features such as shape, surface, so that is the perfect example of shape or surface of an article, or the pattern. Okay, so starting from Dove shampoo, why I have mentioned Dove shampoo here, if you see that a bottle of a Dove shampoo and a bottle of a Sunsilk or a Tresemme, every bottle is different. By looking into the shape of the bottle, even if there is no mark or logo on the bottle, you can identify, okay, this is a bottle of a Dove shampoo and not a Sunsilk. So this kind of design, the pattern, all is actually protected under industrial design. Now the next and very interesting one is the geographical indication. Now before going into the definition that what does this mean, directly come down to the example. Here you can see that Darjeeling tea, Tirupati laddu, and I have forgot to mention the most famous example, Kolkata Rasgulla. Okay, so if you see that each product is identified by the place of its origin. Okay, so what does this mean? So the geographical indications are signs used on goods that have a specific geographical origin. Okay, I think we all know that when Kolkata did not get that GI for Rasgulla, Kolkata was fighting with Odisha, because Odisha was claiming that no, Rasgulla was our invention. So a long legal case went on for I'm not very pretty sure for how long, but still there was a legal war going between Odisha and Kolkata to get the tag that which specific region is actually the origin of this Rasgulla. Okay, so finally Kolkata won that title, and we can say that now it has got the GI. Rasgulla has got the GI, and Kolkata is the place of origin. So similarly, Darjeeling tea, Kolhapuri chappal. So these are actually protected under the geographical indication. Okay, so we don't only say that this is Darjeeling tea. While we are saying that this is Darjeeling tea, we must know that it is protected under geographical indication. Okay, so nobody can ever grow some tea and can label it to be a Darjeeling tea. If anybody, any business owner or any XYZ does that, it will be, he or she or the company will come under a legal, means a case can be filed against that person. Okay, so this is how origin, a place of origin can also be protected for any kind of product. So this is actually the geographical indication. Here you can mention many more. Kanjivaram sari, Kanchipuram sari, these are actually South silk, which is protected under GI because of the place of origin. Kanjivaram, Kanchipuram, these are actually places by which the saris got its name, and alternatively the product got a GI. Okay, now trade secret. Now trade secret is a very important thing for any company who is actually selling their product or manufacturing their product. Okay, so trade secrets are IP rights on confidential information which may be sold or licensed. Okay, so suppose a company is manufacturing some kind of product, so there must be some manufacturing secret, there's some inventive step secrets, and there are many secrets that a company holds while manufacturing a product, and all that secrets will be protected under trade secret. The unauthorized acquisition, use or disclosure of such secret information in a manner contrary to honest commercial practices by others is regarded as an unfair practice, and also it can comes under the violation of trade secret protection. So one must be very cautious to do such kind of unfair means, because you will fall under the violation of this protection. Now we will talk about Protection of Plant Varieties and Farmers' Right Act 2001. So this act, it is in conformity with International Union for the Protection of New Varieties of Plant, UPOV 1978. The legislation recognizes the contribution of both commercial plant breeders and farmers in plant breeding activity, and also provides to implement TRIPS in a way that supports specific socio-economic interest of all the stakeholders, including private, public sector, R&D, as well as resource-constrained farmers. So the main objective behind this act is to establish an effective system for the protection of the plant variety, to encourage the development of new varieties of plant, most importantly to recognize and protect the rights of the farmer, because they are the man behind this new plant varieties. They are the sole contributor who is actually growing this kind of new varieties of plant. Okay, so to recognize and to protect their right is the most important thing under this act. Okay, also to accelerate the agricultural development in the country, protect plant breeders' right, stimulate investment for research and development both in public and private sectors. And also, as I said, that it supports the socio-economic interest. How the socio-economic interest is the interest is met by facilitating the growth of the seed industry in the country, which will ensure the availability of high quality seed and planting material to the farmers. So this is one kind of act where not only the new genetically modified plants or the new plant varieties are protected, but also the man or the human behind growing this plant, their rights are also reinforced and their rights are also protected. So under this act, who are the persons who will be benefited? Not only the farmers, but there are actually 3 persons who will be benefited from this act. So first we will see that The first person to be benefited is the breeder. The second one is the researcher, and the third one is the farmer. The breeder will have an exclusive right to produce, sell, market, import, okay, the protected variety. Breeder can also appoint agent and may exercise for civil remedy in case of infringement, which is very important. Now next, the researchers have the right to use any registered variety for their research purpose or to conduct any kind of experiment. Okay, but for this they have to need prior permission for the registered breeder to conduct their experiment. Okay, since we all know that any kind of legal right comes with three main thing, that is ownership, possession and exclusive right, and this permission is actually coming from the exclusive right that the breeder has. Okay, so any researcher who needs any kind of protected variety should approach the breeder, and with a permission only he or she can conduct the experiment. Now coming to the farmer's right, there are many rights that has been enforced under this act. The farmer is the person who will develop a new variety and is entitled for registration and protection in like manner as a breeder of a variety. Okay, a farmer can save, use, sow, resow, exchange, sell his farm produce including seeds of variety protected under the PPV and FR Act. Okay, also the farmers are eligible for recognition awards for the conservation of plant genetic resources. So there are many rights that are actually enforced under this act, and one of the most important point is there is also a provision for compensation to the farmers for non-performance of variety under section 39 of the act. So suppose any kind of genetically modified seed or plant, they are not performing well in the field, so the farmer is not responsible for that production. Okay, so this is very important point that is under this act. Okay, so there is a provision for compensation to the farmer. Okay, so there are several other points that are under the farmer's right. Now last but not the least, here I have actually mentioned all the years of the Intellectual Property Act. As you can see that the Patent Act was registered in 1970, Copyright Act 1957, Trademark 1999, Industrial Design 2000, GI of Goods Act is also 1999, Protection of Plant Variety and Farmers Right Act is 2001, and Biological Diversity Act in 2002. So there are many more acts, but I have just mentioned these. So this is in brief the lecture on fundamentals of intellectual property rights. Hope you have understood and enjoyed. Thank you.